Ooh, all right, we're up to 71 participants. That's great. I guess I'll go ahead and get started and folks can join as they are able to call in. So I want to welcome everyone to the federal contracting portion of the CRA study group. My name is Eileen Gallagher, and I am the Director of Contracts in the Office of Sponsored Programs at George Mason University in Fairfax, Virginia. For those of you who don't know where we are, we're just a little bit south of Washington, D.C. And I've been providing the training for this issue for a couple of years now, and I'm happy to continue and happy to hear Eric just describe what high success rates this group has in the test. So good luck to all of you. So let's jump in and talk about federal contracts and grants. So let's first talk about what the difference is between a grant, a contract, and a cooperative agreement, because they are very different vehicles and there are distinctions that are important for you to understand. So let's start with the easiest one to administer, and that's a grant. A grant is known as a financial assistance mechanism providing money, property, or both to an eligible entity to carry out an approved project or activity. So this is when the federal government identifies a need for the benefit of the public and wants to provide money to an eligible party. The proposal guidelines will talk about who's eligible to submit a proposal for a grant. And they want to give the funds, but they don't want to have any programmatic or substantial involvement with the project. They just want to basically pay a grantee to perform the work pursuant to the statement of work they included in their proposal. They're not going to have their scientists standing side by side with our scientists. They've got a statement of work. They want us to perform. They want us to give them progress reports, and they usually fully fund the project, and you don't need to worry about money expiring at the end, at the crossover of federal fiscal years. The characteristics of a grant include an objective to advance science for the benefit of the public. That's an important distinction, because when we get to a contract, you'll see that the objective is to advance a concept for the benefit of the government. So a grant is for the benefit of the public. The primary purpose is for basic and applied research. Publication is encouraged. Obviously, it's for the public benefit, so we need to get the research results out to the public as quickly and easily as we can, so that we can share the knowledge that the government has paid us to develop. Grant terms are more flexible, less restrictive, and much easier to administer than procurement contracts. They're primarily awarded to educational or not-for-profit organizations. Sensitive, secured, or classified information is usually not involved, obviously, because publication is encouraged, and this is for the benefit of the public, so we're obviously not going to share our national secrets with members of the public or put them in the public domain. So publication is always expected as a result of a grant. A university or a grant recipient, not just a university, a grant recipient is not entitled to charge a fee or profit. And this gets to be a problem when you issue a subcontract to an entity who might be a for-profit commercial supplier, and they want to put a fee or profit line item in the budget, and you have to tell them that they can't, because government will not allow fee or profit as an allowable cost on a grant. You can charge your indirects, of course, but not fee or profit. If it's a Department of Defense grant, you've got your Department of Defense grant regulations applying. Of course, OMB uniform guidance applies, but grant terms are not subject to the Federal Acquisition Regulation. It's not a federal procurement contract, so it's not subject to the FAR. Substantial government involvement between the granting agency and the recipient are not anticipated, so the grantee has the ability to perform independently. You have to provide the government with a minimum with at a minimum a paid up royalty-free license to any intellectual property that's created under the grant. That means you can still, the grant recipient is allowed to retain ownership of the intellectual property it develops and can commercialize it however it chooses, but you must give the government what we call government purpose rights without charging them twice. So in other words, they've bought and paid for the right to use the intellectual property that you develop, but then you're free to do whatever else you want with it yourself as an award recipient. And the government reserves what they call march-in rights to any patent, any intellectual property that you developed. And what that means is, the purpose of this funding is to get research results out into the public domain. And if you're not doing that as the grant recipient, they're going to exercise march-in rights, come in and do it in your place, because they want you to fulfill their purpose of disseminating this information as greatly as possible, as widely as possible. And they realize that the universities and other not-for-profits are in a much better position to do that than the government themselves. But if you're not doing it, they'll come in and do it because they want that information out to the public. So the next type of award that the government will issue is called the cooperative agreement. A cooperative agreement is also a financial assistance mechanism used when there will be substantial federal scientific or programmatic involvement. Think of it as a grant where there is a federal scientist who is standing side by side your scientist in a lab working together. So it's still not a procurement contract, but there is, you don't have that same sense of independence that you would have under a normal grant. Substantial involvement means that after the award, the sponsor, scientific, or program staff will guide, coordinate, or even participate in project activities, unlike a grant. So the characteristics of a cooperative agreement, used when a grant is determined to be inappropriate, meaning they want some say in the guidance and to steer the research along in the direction of their choosing. Substantial government involvement is anticipated. Either a program manager or an actual scientist are collaborating with your PI at every main point in the research project. The government, again, just like a grant, the government will receive a paid up license and march-in rights to intellectual property that's developed. Again, they want research results to get out for the benefit of the public, and will do whatever they need to do to make that happen. Again, like a grant, no fee or profit is allowed. Cost share may be encouraged or required. The program guidelines, the RFP or solicitation guidelines will specify. And if it's a Department of Defense grant, then the DoD grant and agreement regulations apply. Again, it's not a contract, it's still a financial assistance award, not a procurement contract. So cooperative agreements are not subject to the FAR. Now we're into the world of contracts, much more complicated, much more burdensome to administer. A contract is defined by the FAR as a mutually binding legal relationship obligating the seller to furnish the supplies or services and the buyer to pay for them. In our cases, the university would be the seller and the buyer would be the federal agency. The primary purpose of a contract is to deliver goods and services for the benefit of the government. So it's not a public financial assistance award. It's paid with federal appropriated funds, which means you may have a 5-year, $30 million contract, but you're only going to get funds 1 year at a time as appropriated by Congress. And the FAR is subject to the federal acquisition regulation. There are different types of contracts. Cost reimbursable contracts are the most common and the preferred type of contract for a university to receive. A cost reimbursable contract is when the contractor is reimbursed for allowable costs incurred during contract performance. A total cost estimate is prepared and the award contains a ceiling that may not be exceeded without sponsor approval. And OMB uniform guidance cost principles apply here. So a cost reimbursable award is basically has a contractor invoicing monthly in arrears. So you have to wait until an actual cost hasn't been incurred, hits your books, and then you invoice for reimbursement. And you also have to pay attention to what kind of documentation a federal agency requires. Do they require receipts? Do they require, or do they not? A lot of times travel and per diem, like if you're traveling, you'll need to provide receipts for that, but other things you might not need to. So the contract will specify what needs to be what costs need to be documented and what are accepted. So cost reimbursable, you invoice in arrears after an actual cost has been incurred, and you invoice only for that actual cost amount. Fixed price contracts are issued when the sponsor determines that the price quoted is reasonable and does not want to give the contractor an opportunity to adjust their price based on actual expenses incurred during performance. The completion of a task or milestone usually renders a payment due. They're easy to administer, but they pose a slight risk to the contractor, because if your proposed budget is off and you do run in, or there is an unexpected event that requires you to incur additional costs, you have no mechanism to go back and request additional funding. So there's the risk that you run into a cost overrun and then you have to eat those additional costs. But then there's also a benefit. If you come in under budget, you're still entitled to invoice for the full amount of that fixed price award, and you might make a little bit of a profit. So it's a sort of a business decision. And you want to make sure, though, that your budget is really thoughtfully prepared so that you try to avoid any risky eventuality. You can also, the government will also issue what they call IDIQ, or indefinite delivery, indefinite quantity contracts. They're issued when a set quantity of goods or services are needed, but not known or specified at the time the contract is issued. So what they'll do is they'll know that the government knows it has a need. Let's say it needs to buy the services of 500 training hours for classified engineering work. And well, they don't know if it's going to be needed this month or next month or 6 months from now. So they'll give you an award for the services where you negotiate the terms and conditions, you agree upon a statement of work, you agree upon a general price, and then they'll issue task orders under the IDIQ, which state exactly the amount of service they want for the price they're going to pay, and it will tell you when and where to perform. So you've already got a negotiated contract in hand, but there's no specific performance required at the time. But maybe 2 months from now, they'll say, oh, we need a trainer to go out to San Diego and provide training on this. So here's your task order. Go to San Diego, provide the training, and invoice us your costs. And then 2 weeks from now, you might get another one that says, send your trainers to Albuquerque, and the same kind of thing. So you don't have to go through and negotiate contractual terms and conditions each time. You do that once at the beginning, get that out of the way, and then they just issue the task orders with the specific statement of work and the attached funding to it. Now, an IDIQ doesn't really have any money on it. meaning no checks are going to be cut and coming your way until a task order is issued and executed. But there is going to be a dollar value ceiling on it. So they'll say, the ceiling is $1 million. So the sum total of all the task orders they issue under that IDIQ cannot exceed $1 million. But it doesn't mean you've got $1 million in your hand until the task orders follow. I hope that makes sense. Another popular type of contract the government likes to issue are time and materials. These allow a sponsor to acquire supplies or services based upon specific labor hours and actual material costs. Universities hate these. It's almost impossible for us to accommodate the hourly timekeeping requirements that a time and materials contract requires, such as you have to, on your invoices, you have to list exact hours. You have to certify those exact hours performed. But the problem with the university is we're all set up. Uniform guidance mandates universities are set up to track labor by a percentage of effort, not hours. So we don't have the backup documentation that would survive audit scrutiny to back up those exact hours that we're certifying. So we try very hard not to accept time and materials awards. And instead we try to argue that a cost reimbursable award is the next best thing, because all the costs for all the materials and supplies, et cetera, are on a cost reimbursable basis. And our effort still is on a cost reimbursable basis. We just can't certify the hours that we're expected to provide. So we always try to convert it to cost reimbursable or cost plus no fee, because we're not for-profit entities. As long as we don't have to report and certify actual labor hours worked, we're good. So I've mentioned the FAR a couple times, and now we're gonna talk about what the heck it is. So the FAR stands for the Federal Acquisition Regulation. It's a body of laws governing federal procurement contracting. It appears in Title 48 of the United States Code of Federal Regulations. These are all laws enacted and approved by Congress. So when you're arguing with a subcontractor, why is this FAR requirement in here? You say, I don't know, ask your congressman. It's not up to federal contractors. So the FAR is a very thick body of law that's composed of a few different chapters. Chapter 1 is the basic FAR, which is a book about, probably 3 inches thick. It's a big, hefty volume. And that's what every federal agency is required to follow. Then each specific agency is also allowed to issue their own FAR supplements. The most common one is the DFARS, which stands for Defense Federal Acquisition Regulation Supplement. And that is known as Chapter 2. So we got part 52 of the FAR, which is the FAR clauses that we're going to discuss. But then if it's a DFARS clause, it's going to be 252. You don't need to know this for the exam. I'm just giving you a little background understanding. But you do need to know that federal agencies are entitled to issue their own FAR supplements that supplement the basic FAR clauses, cannot supersede them or contradict them. The basic FAR, which is applicable to all federal agencies, they must follow it. They cannot deviate. Their FAR supplements can add additional requirements, but cannot remove or alter them, the current ones. We also have, the end of the FAR includes all federal standard forms, so you can have an opportunity to see what they look like. And then parts 1 through 51 are the FAR prescriptions. So 52 is the clauses, the requirements, the laws, And when though a particular clause applies to a contract will be explained in parts 1 through 51, which sets forth when a clause is prescribed for use in a specific contract. Oops, went too far. So most federal agencies do have their own federal supplemental acquisition regulations. I mentioned the DFARS, that's the most common one. NASA has a FAR supplement. The Department of Education has a FAR supplement. Every department I'm aware of has them. Department of Energy, Homeland Security. They're all available online. So if you are looking at a particular clause, you can see what the full text says by looking it up. We're going to go through some of the most important FAR clauses that you need to be aware of and the issues that they bring. So I have, they're coming up momentarily. So the purpose of the FAR is the benefit, to serve a benefit to the federal government in terms of cost, quality, and efficiency. So the government say with a standard set of regulations on how to procure goods and services, the government saves money in both administrative and the price of the services themselves because it fosters government competition. So the government is more likely to get the best value for goods and services if everyone is competing on a level playing field and is required to follow the same procedures. The FAR establishes uniform acquisition procedures for all federal agencies. It promotes competition among government contractors, which ultimately saves the federal government and us taxpayers money. It minimizes the administrative operating costs associated with procurement contracts. It allows the government to obtain services at the best value. It allows the government to conduct business with integrity, fairness, and transparency so that there's no favoritism or no money under the table kind of situation, ideally. The FAR is consulted whenever a prime contractor is responding to an RFP or completing the reps and certs that are required for all federal proposals. And then after receiving a federal prime contract, your contract's going to be loaded with FAR clauses that are either incorporated in full text or incorporated by reference, just giving the FAR clause title, and the date that title of that clause was last updated. So you're just going to see a big, huge list of FAR clauses that just are referenced, the number and title, but they are deemed to be incorporated as if they were included but in full text. It saves just paper, I think. We need to be aware of the contents of FAR clauses when we receive a subcontract under a federal prime. And when we're issuing a subcontract under a federal prime, a university has to flow down all the terms and conditions of the prime award so that our subcontractors comply with federal requirements because we are responsible for their activities and we want to make sure that they are in compliance as well. The contracting officer at the government, when they're issuing a contract, they use a standard federal Form 33. So it's a uniform contract template that is consistent in all federal awards. So if I'm looking at if I receive a contract and I want to go right to, what's the statement of work? I know that I can always go to Section C and the statement of work will be there. Or if I want to find the specific contract clauses, the FAR clauses that are incorporated, I know I just go to Section I. And it's always consistent. So it's really handy to just know that every federal contract is set up in the same format. So the federal contracting process, let's walk through that from cradle to grave. So we have a pre-proposal phase where a government agency identifies a need. A PI may be in discussions with a federal technical representative. I'm always amazed at how our university faculty have friends and colleagues who are federal employees, or there's just this vast network among their specialized area, and they seem to know everyone and they hear about things before they hit the streets. So sometimes they're going to hear about stuff well before it becomes public. But if that's the case, then they might be wanting to talk with some other collaborators, and they might want to get a non-disclosure agreement or a teaming agreement in place. And then when the solicitation, also known as RFP or RFQ, is public, they're ready to submit a joint proposal. So the solicitation, also known as RFP, request for proposal, or RFQ, request for quote. The government advertises the need to the public, inviting proposals to be submitted. This must be made available to the public. There cannot be any backdoor negotiations. It's possible that a government may accept an unsolicited proposal for a need that is presented to them, but there is a whole different set of procedures for that, and it's not as common or as encouraged as the formal RFP process. So the solicitation hits the streets, and it includes that standard format we just talked about with the solicitation, the offer and award. So you have an opportunity to see what kinds of terms and conditions are going to apply to your contract, even before you have the contract. It includes a period where questions are welcome, or if you have a request for clarification. Sometimes the RFPs are not worded very clearly, and there's a period with very defined start and end dates where anybody is allowed to ask a question of the government contractor responsible for this RFP. So but in all fairness and in favor of transparency, these questions are posted to a publicly available site so that everybody who's interested in this has the benefit of your question and your answer. And then after the period closes, you can no longer go back to the government and ask for clarification or ask for questions to be answered, because that's giving an unfair competitive advantage to one party at the expense of others, and the FAR prohibits that. So now your entity has decided to submit a proposal. You're in the proposal preparation phase. You've submitted it. The government reviews it in connection with all others that come in. The first thing they do is they look to see that you are compliant with all of their guidelines. And some of these guidelines can be really narrow and dig into minutia. Like, they want size 10 font instead of size 12 font. And if you submit a proposal in size 12 font, it is non-compliant and they will not read it. Or there might be a page limitation. You may not include more than 10 pages, and they will not read anything past page 10, even if the meat of your proposal appears on pages 11 and 12. They will consider your proposal non-responsive. So you have to make sure that the proposal meets all RFP guidelines, or it will be summarily dismissed. And if there are provisions in there that you as a potential prime contractor want to take exception to, they must be identified in the proposal, because you may not have another opportunity to negotiate terms and conditions at the award stage. Your proposal must include a technical solution and your budget justification, and it has to be in the exact proper format that the solicitation mandates, or it is not going to be read. So let's say your proposal is selected for funding. They come back, they ask you to review the terms of the award. Sometimes they don't allow for a negotiation period. You had that opportunity at the proposal stage, but sometimes they will. It's kind of, I don't know if there's any particular rhyme or reason to it. Sometimes I'm given a draft copy in advance and say, hey, do you have any issues with this? But sometimes it's a, here it is, pre-signed by the government, take it or leave it. So that's why your proposal has to be very carefully crafted to avoid any situations where you don't want to be forced into accepting an award or a provision that your university can't comply with. For example, let's say you're a university that can't accept classified material, and all of a sudden the award has FAR clauses and DFARS clauses that include classified research. Nope, can't comply. I don't have a classified facility. I've seen weird things like that where we've submitted a proposal, they did not identify it as a classified award, and then I got the contract and it was. So they, you never know what's coming at you. And you want to make sure that the terms are consistent with your university policies and the state requirements that your university operates under. So the award then, the federal agency issues the award incorporating all necessary FAR and supplemental regulations, but those can often include certain types of troublesome clauses, which we'll discuss in a bit. Sometimes you have to work around them. We'll discuss those sort of one at a time in a few minutes. And then you have the contract administrative phase. You've got post-award activities and obligations that are performed by both the government and the award recipient. Such as the delivery and acceptance of financial and technical reports, the process, should there be any disputes, or if there's the need for any modifications, like a no-cost extension, our PIs didn't finish the work in time, they need an additional 3 months, or it's a cost reimbursable award, we ran into some unexpected costs, can we receive additional funding? Or we've got a PI change, can we change key personnel, things like that. So you handle those through modifications to the award. And as I mentioned, contracts are tied to congressional appropriations. So if you've got a multi-year contract where you're expected to get $5 million a year, and September 30th, end of the federal fiscal year rolls around, your money's gone. Unless your contract allows for carry forward, meaning unspent money from one federal fiscal year can be carried across into the next fiscal year, or you get your next increment through a modification from the contracting officer. And then there are also termination and closeout procedures that have to be followed at the end and wrap up phase of a federal award. Closeout cannot occur until all services have been performed, all deliverables have been submitted to the government and accepted, any disputes have been settled, any classified material has been properly disposed of per the terms of the contract. Either they want it returned or they want a certification that you've properly disposed of it or destroyed it. You have to fill out a form that discloses any patents or discoveries that the government might be entitled to have government purpose rights for, or even outright ownership if it's that type of award. That all government property purchased with federal funds under the federal award have been accounted for. A lot of times, and I would say in most cases, the equipment that's purchased with the funding and used under a federal contract, the ownership will vest in the award recipient, which is a great kind of boon to a university. You get a lot of awesome equipment that way, but you still have to account for it. You still have to report what you've purchased. And then you have to make sure that your university has a government property tracking process in place. And closeout cannot incur until the final invoice has been paid, and then any remaining funds have been deobligated. Now, this is kind of funny because there are times when an award is closed, maybe we've got $3 left unspent in a cost reimbursable award. And 2 years later, I'll get a modification that deobligates $2 from an award that we've had closed out forever. But the government, I guess they're a little slow in closing some of these out, but they will literally deobligate $2 through a formal modification so that they can close it out on their books. All right, so let's talk about a contracting officer. Who are they? And what is the difference between a contracting officer and a contracting officer's technical representative? A contracting officer is authorized by a government warrant to issue awards and modifications. They are authorized to legally bind the government, as opposed to a contracting officer's technical representative who was appointed by the contracting officer to monitor technical performance and progress, to review and approve deliverables, to review and approve invoices, but the COTAR, as they're affectionately called, has limited authority and cannot legally bind the government. And here's a problem. Our PI and the government's COTAR are having conversations because they're talking about the technical progress that a research project is making. And a COTAR gets a brilliant idea. Hey, instead of doing what we plan to do, let's change this research up a little bit and let's do Y instead of X. And if that costs more money, I'll get you the money. So RPI, acting in good faith, does Y instead of X. And sure enough, it does cost extra money. And then we go to invoice for it. And the government contracting officer says, oh no, I didn't authorize that. The COTAR who did direct you to do that is not authorized to commit the federal government. So all that extra work you did and that extra expense you incurred, that was done at your own risk, and there's no money to reimburse you for that. So you have to be careful and make sure that you don't deviate or incur any additional costs or any material change to the contract without the contracting officer's written approval. But contracting officers are not technical experts. So they look at an invoice, they look at a technical progress report, and they can't make heads or tails of it. So they appoint a COTAR, someone who is knowledgeable in that technical field, to actually monitor the project and stay in touch with the progress. But that COTAR's word does not legally bind the government like a contracting officer's does. That's an important distinction. So when we're looking at FAR clauses and other provisions of a contract, we want to look from a university's perspective, we want to look at the ability to publish, the right to retain title to intellectual property. In other words, we don't like any provision that says this is work for hire, because work for hire is a legal term of art under federal copyright and under federal copyright law that says we're paying you as our virtual employee to do this, and all employees' intellectual property belongs to their employer. So we don't like that. So look for that. We also want to be able to retain title to property and equipment at the closing of the contract. Not only because it benefits the university, but it's also because if we purchase big, huge computer servers, we have to pay to get them back to the government. And that's a big, expensive shipping cost. We have to look for the fact that the contract applies the appropriate cost principles applicable to universities. We are not a for-profit commercial supplier. We don't operate under the same cost principles. So we want to make sure that the appropriate ones are included in a contract. We want to be able to a way to determine allowable costs. And we also, as universities, want to know very clearly up front whether we're allowed to include foreign nationals as research participants, because if your university is anything like ours, you've got a lot of international faculty and students. And if foreign nationals are not permitted to participate, then what do we need to do to secure the research and research results from foreign nationals who might be walking through our halls and walking through our labs? So we need to know about that, and we'll talk more about that in a bit. So I'd said before that if we look at a FAR clause, we don't know what it means. We don't know if it applies. We don't know if we want to question its inclusion in our award. So we go back and we read the prescription that spells out why that clause is included in a contract. And that gives us the rationale for why it's included and identifies specifically when it's required. And that will assist a university in determining whether they can challenge its inclusion, such as, I often see this indemnification clause in one of the in almost every contract that deals with indemnification for software developed in case we infringe on anyone else's patent rights. And if your university's like ours, we're not allowed to include accept indemnification provisions. So I can go back to a federal contracting officer and say, hey, we're not developing any software. This clause doesn't apply. And then I'll have a really strong case for the contracting officers to remove it for me. And then I get around the indemnification issue. So the prescriptions are a really helpful tool. So these are some of the problematic clauses and areas that you need to be aware of. I do not think that the CRA exam does not expect you to memorize the special works clause is FAR 52-227-17. They don't. You're expected to understand the issue and the principles, but you're not expected to memorize to this minute detail. So don't stress over that. So there's a FAR clause that appears in a lot of contracts that prevents the release, distribution, and publication of any data first produced in performance of this award. This, we don't like this because this is contrary to the mission of a university whose goal is to disseminate information. And this says that all deliverables will belong to the government. So the prescribing clause, the prescription says that it's limited to situations where in limited situations, this clause is required, but it should be removed unless it directly applies, such as when the research is for internal government use only. So let's think of like classified and contracts. We're never going to remove this from a classified contract because they do not want anything released, distributed into the public that's classified. So if I've got a classified contract and I want to try to remove this, I'm not going to have any leg to stand on. But if it's something for basic or applied research, I'm going to have a really good argument that, there's a public benefit here, that in addition to a governmental benefit, let me have an opportunity for my faculty and any student researchers on the project to publish and be more consistent with a university's mission. Rights and data, another problem clause. This allows a contractor to establish a claim to the copyrightable data first produced, and it's specifically used for contracts. Oh, sorry, that was the alt version, sorry. This requires prior written consent of the government to establish a claim in copyrightable data first produced under the contract. Well, there's also a handy alternate version of 52-227-14 that applies more toward universities, where it says that a contractor instead of the government is the one that can first establish the claim to the copyrightable data, especially because what we're doing is fundamental research meant for public dissemination. So it doesn't mean the government isn't going to get government purpose rights that it has already bought and paid for, but it allows the university to use it as freely as it wants or needs to, which includes a student's right to publish. So if you've got a graduate student who needs to publish for his or her master's or PhD, they're going to need to publish. And clauses like these in contracts can be a roadblock toward that publication right and therefore toward earning their degree. So you have to be careful. This is a Department of Defense, a DFARS clause. See how it has the 252, 204-7000. This is one that prevents any release of any information resulting from the research project without contracting officer's approval. Not COTAR's approval, but the contracting officer's approval. And this serves as a publication restriction, which has serious implications to universities. It takes us out of the fundamental research world and it puts us in the world of export controls if the government has put a publication restriction on it, and our approval is subject, our ability to publish is subject to the approval of contracting officer. And believe me, contracting officers will decline approval. And that can leave your university faculty and students in a terrible situation if they weren't planning on it. So this is a very problematic clause for universities, and one we try to work around by arguing that we are not working with classified or sensitive information, which we understand that is not appropriate for public release, but we're doing fundamental research and we would like to remove this or alter this or get a fundamental research exclusion carved out of our award. See, it serves as a waiver of the university's fundamental research exclusion to export control laws. And as of 2013, they allowed subrecipients to scope out a fundamental research portion of their statement of work. But I've actually had faculty say, if this clause remains in my contract, I can't work because I need students. The students need to publish. They won't participate if they can't publish, so I don't have the support. So this is one to look out for. It serves as a publication restriction that universities seriously frown upon. The federal government is now requiring specific controls over unclassified information as well. This is a hot topic in the world of federal contracting, big time. So they started doing this around 4 years ago when, everything that's classified, that's clear. It's either classified or it's not. It's either sensitive or it's not. It's either appropriate for public dissemination or it's not. But then they opened up this whole new body of data, government provided data, which is unclassified, but they still want it safeguarded. So they started in 2016 by issuing this FAR clause called Basic Safeguarding of Covered Contractor Information Systems. So when government information is being provided to a researcher, they have to store that data on a computer system that meets specific security safeguards. So there are 15 security safeguards here. And they're the basic ones that, hence the name Basic Safeguarding. It's basic. It's, password protected. Like two-factor authentication is required in order to access the database that it's stored on. Simple things. This clause applies to all federal agency contracts and is in addition to any specific agency requirements. So this sort of laid the groundwork for protecting unclassified data. And when I'm talking about what is considered covered data, I'm talking about things like export control technologies. Things we don't want our foreign, I don't want to say enemies, but our non-friendly foreign neighbors to have access to. Protected health information of individuals. Anything that's identifiable, like a student applies for federal, a college student applies for federal grants, and they fill out the FAFSA form. The FAFSA data that the students provide is covered, and we have to keep that secured. So even your admissions office is subject to the basic safeguarding requirements of the FAR. So it has pretty long tentacles. Then the Department of Defense added a supplemental regulation piggybacking on the basic safeguarding FAR clause, which requires safeguarding of all controlled government information, any technical information with a distribution statement B through F limitation, I'll explain that. A critical system operation secure, all critical system operation security information, export controlled information, etc., has to be stored in accordance with the National Institute of Standards and Technology, NIST, Special Publication 800-171. Now, instead of 15 security requirements, the NIST 800-171 document imposes 109 security requirements. And I am not technical enough to even go through what that involves, but your IT folks do and know, and I'm sure they're all on it, because this was a drastic change when this came out. So what I mean by any technical information with a distribution statement B through F, the Department of Defense classifies different types of information. Distribution statement A says this information is free to be disclosed publicly. Distribution statement B might say this information is to be used, may be used publicly with government contracting officers' approval. Distribution statement C says this publication or this information may be distributed only to internal governmental employees. All the way down to, so it gets gradually more restrictive until you get to distribution statement F, which is basically top secret classified information cannot be shared with anyone without a clearance in the program office. So we look for, as a university, we look for distribution statement A because that's consistent with our mission of sharing to the public. But, a lot of research money falls under some of these more technical contracts. And this DFARS clause, what we call DFARS 7012, appears in every single Department of Defense award. And you just need to be aware that when you see that, it means you've got 109 special security safeguards that you need to comply with. So controlled unclassified information is part of the federal Code of Federal Regulations. It applies to all federal grants and contracts. It creates a uniform CUI, controlled unclassified program, to establish policies for designating, handling, safeguard, and disseminating CUI. Two basic types, there's basic CUI and there's CUI specified. Basic CUI is the basic categories I mentioned, such as, student data, personal health information, PHI, export control data. CUI specified will be spelled out by the terms of the contract and could be unique to that particular award or project. This whole new CUI world is governed, believe it or not, by the National Archives and Records Administration, who oversees the compliance issues with this. And federal agencies are free to add their supplemental regulations, and boy howdy did the Department of Defense jump right in and do that. So there's another clause. Here's one that's not a problematic clause. It's actually one we really, really like. It's the authorization and consent clause of the FAR, which allows a contractor to use any invention covered by a United States patent to accomplish the research covered under a contract. We do like Alt 1, which removes the patent indemnity provision. But here's what this means. So I'm paid by the government under a government contract, not a grant. Please know the difference. A government contract to perform a research to develop a new satellite. And let's say in order to develop this new satellite with the specifications that the government wants, I need to use a patent that's already been filed by SpaceX. Well, I don't have to pay a royalty to SpaceX to use that patent, to use their technology in performance of this government contract. I can use it because the government sort of oversees all patents and has rights that are in the national interest. And under the authorization and consent clause appearing in federal contracts, I'm allowed to use someone else's patent to develop and deliver an end product to the government. Now, that does not mean I can then sell my patent that includes SpaceX technology for a profit without going back and giving them a portion of the royalties. But I'm not in violation of their patent by using it for the government, for purposes of performing under that government contract. Now, there's also a patent indemnity provision, which we as universities who can't indemnify don't like seeing. So we are often able to request the deletion of this clause in favor of the authorization and consent clause that we just mentioned. I know if your university is like mine and we've got a very strict state law that prohibits universities from committing the Commonwealth of Virginia to indemnification provisions in sponsored research contracts, if I can't get it out of a federal contract, then that's a deal breaker and I can't accept it because I can't comply. So watch for FAR clauses that include these kinds of problematic terms. Now here's a patent clause that I love. 52227-11, patent rights retention by the contractor allows the university to elect the right to elect ownership of all patents it develops under the contract, free and clear of any governmental restriction. It implements what's known as the Bayh-Dole Act. The Bayh-Dole Act is a federal law which promotes collaboration between commercial concerns and not-for-profit organizations such as universities. It promotes the use of inventions arising from federally sponsored research and development awards. It ensures that government-sponsored inventions are used to promote free competition and enterprise, and allows universities to retain title and file for patent ownership on inventions that they select to own. A lot of times universities don't want to pursue a patent because they're expensive and they may not feel they're going to get a good return on the $30-some thousand it costs to secure a patent. However, even though we can own it and we can sell it and we can do whatever we want to do with it, we still have to disclose it to the government as part of the award closeout or within 2 months of its initial discovery. And the government does retain government purpose rights to it. But you know, a government agency is not in the business of selling and marketing products. So they're not going to be our competition in the marketplace. They just want to be able to use it for other projects that may arise over time, and have the ability to do so without coming back and securing the right again. FAR 52-215-2, audit and records negotiation, establishes the government's right to access and audit a contractor's records. Per the prescription for this clause, we want to request an alternate version which implements OMB uniform guidance, which is formally A133, audits of state and local governments and not-for-profit organizations. This clause and its incorporation of OMB uniform guidance talks about how for a cost to be legitimate, it has to be allowable under the award, it has to be a reasonable price, and it has to be allocable to that specific contract. Meaning I can't buy a piece of equipment on contract A and then charge it to contract B. Allowable cost and payment clause establishes which cost principles apply to the contractor. Obviously, we want OMB uniform guidance. We are, that is specifically for, drafted specifically for universities. We comply, all our systems and financial record keeping devices are all set up in compliance with uniform guidance. There are other cost principles that apply to for-profit commercial suppliers. We don't want to be held to those standards. We don't meet all those requirements. We love this one, cost accounting standards for educational institutions, specifically tailored to us, which includes OMB guidance. And OMB guidance, as you know, combined all the old OMB circulars, including A21 cost principles, which sets forth which costs are applicable under contracts. And again, this is a big issue. The OMB uniform guidance requires a cost to be allowable, allocable, and reasonable. And this is embedded in various FAR clauses, and we like to see those. Limitation of funds. This is important. This one I think is a frequently tested topic on the CRA exam. The FAR clause involving limitation of funds requires a contractor to notify the government when expenditures reach a certain threshold, usually 75% unless otherwise specified. If expenditures are more or less than the obligated total. So you've got a requirement that you have a 60-day period. If you reach the 75% threshold and you don't think you're going to finish or be able to meet all contract deliverable requirements with the remaining 25% of funding left, you have a 60-day period to request supplemental funding or a no-cost extension to the contracting officer. And the contracting officer, if it's a cost reimbursable contract, will consider your request. And sometimes they actually come through with extra money, or most of the time they come through with a no-cost extension. It's really rare that you don't get at least one or two no-cost extensions on federal awards. But if you wait until beyond the 60-day period, after you've reached 75%, your window of opportunity to request this additional funding has closed, and you now have to perform at the original price awarded, and you have to make up the difference. There are government property clauses in federal contracts, and this particular clause gives the contractor title to property and tangible assets purchased with federal funds when the acquired property is less than $5,000. The government contracting officer has approved the purchase and requires the property to be labeled, tracked, and reported on a federal form DD 1662. So this is that DD 1662 is part of the closeout process. We have to report all property purchased. And the reports must be submitted annually and are absolutely required for closeout. The acquired property greater than $5,000 is actually termed equipment. And your contract will specify how ownership vests in equipment purchased under the contract. There are also Buy America Act provisions in contracts which limit the purchase of commercial items to domestic end products. Exceptions can be authorized by a contracting officer when it's in the public's interest, or there is no product that's suitable that is made in the United States and you have to buy a foreign product. And the same principle applies here with Fly America Act. Transportation on government contracts must occur on a US flag air carrier. There are exceptions if no US carrier flies on the route you need, or a US carrier involuntarily reroutes a traveler to a foreign carrier, and that was beyond your control. I actually had a situation where our faculty was required to go to Montreal under a federal award, and they flew Air Canada, or they bought tickets on Air Canada because they were actually cheaper. But then when we submitted the receipts, the contracting officer rejected and said, no, you are in violation of the Fly America Act. We are not reimbursing this. So they mean business. Okay, I know I've been going through this pretty fast, but I'm going to change gears here. And I'm now going to talk about the subaward process and the subrecipient monitoring responsibilities that a prime contractor, excuse me, that a prime contractor has when issuing subcontracts under its prime award. Subrecipient monitoring responsibilities are outlined in Uniform Guidance sections 330 to 332. And these are federal requirements, and I'm going to kind of go through the highlight the most important ones for you. So when we talk about subawards, I want to make something clear. I want to talk about the two types of subawards. There are two types, where the prime sponsor goes through a pass-through entity and you are the recipient of that award. Well, that's a subaward. It's not the kind of subaward I'm going to be talking about today. That's an incoming kind of a new award to your institution. I'm going to be talking about the outgoing subawards, where a prime sponsor issues an award to your institution, and then you issue a lower tier subaward to a sub-recipient as selected by your principal investigator. That's the process I'm going to be talking about. I just wanted to make that clear. So first thing, you need to make a determination on who's a subrecipient and who's a contractor. And it matters because subrecipients aren't contractors and contractors aren't subrecipients. And you'll use two different payment vehicles to pay them. So this determination needs to be made early in the process, usually around the proposal stage, so you can budget it accordingly. So a subcontractor, a subaward is issued and administered by your sponsored programs office. A subaward is for the purpose of carrying out a portion of the federal award and creates a federal assistance relationship with the subrecipient. Characteristics which support a subrecipient classification include: has their performance measured is their performance measured in relation to whether the federal programmatic objectives are met? do they have responsibility for programmatic decision making? Do they use federal funds to carry out a program for public purpose specified in an authorizing statute, such as opposed to providing goods or services for the benefit of the pass-through entity? If they're a subcontractor, then they are subject to all federal program requirements specified in the prime award. So let me continue, and then I'll further explain. So the use of a purchase contract for a contractor, they're paid by a purchase order, which is administered, I know at Mason, it's administered through our purchasing office, not our sponsored programs office. A purchase order is for the purpose of obtaining goods and services and creates a procurement relationship with the contractor. Characteristics include providing goods or services within their normal business operations, provide similar goods or services to anybody who walks in their doors and asks for the item, normally operates in a competitive environment, provides goods and services which are ancillary to the operation of the federal program. They're not part of the programmatic decision-making progress like a subcontractor is, and they're not going to be subject to all federal program requirements specified in the federal award. So if I'm going to buy the services of an engineer who is going to help me design a particular type of landmine detector, and I have a very defined, unique scope of work, and they're going to be using their expertise to tell me where the scope of work is correct or might need improvement or might need revisiting, then they're going to be a subcontractor because their participation is at the heart of my ability to comply with the contract. If I'm going to buy the services of an accountant who provides the same type of business accounting to everyone who walks into their office, and there's nothing unique or specifically tied to that project itself, they're going to be a contractor. They're not going to be subject to all the prime award terms and conditions that I'm going to float. I mean, I'm not going to float them down because they're not going to be applicable. So it's important that you see the difference. And the best part about these bullets on this slide and the slide before come directly out of the uniform guidance. And the best part about all of this is that even though it's sometimes difficult to determine who's going to be a subcontractor and who's going to be a contractor, OMB allows for the exercise of judgment. So they recognize that it's not always going to be black and white or clear as day. So they allow for the exercise of judgment. I have one story that I'm going to go to my grave being upset about this. I had a PI working on a State Department award. And when he was going to Jordan, the country Jordan. And when he got to Jordan, he wanted to hire a driver and sort of a tour guide to sort of navigate them around. And to me, that is clearly a contractor because that driver is going to drive a car for anybody who asks them. They have no involvement in the success or failure of the research itself. And I went to battle with that PI to convince him we're not issuing them a subcontract. You pay them through a purchase order. And this was elevated to the highest levels of the university when finally we won and said, no, pay them with a purchase order. And then I found out it was the guy's brother-in-law. So sure. But it matters because the way you budget it. We can only collect indirects on the first $25,000 of all the subcontracts, regardless of the amount of the overall subcontract award. But we can collect indirects on all the income from all the fee that's going to a contractor. So it matters. And that's why you need to make a determination earlier in the process rather than later. The FDP actually has a really handy tool based on the uniform guidance bullets that I just discussed. So if you ever get in a situation with a PI, you can just say, hey, fill out this checkbox and show me what you're saying. But be aware of that because it's an important distinction to know. So planning for a subaward. At the proposal stage, the PI will identify a collaborator who will have significant involvement. The OSP, your sponsored programs office, will work with the PI and the potential subcontractor to collect a subrecipient commitment form, their W-9, their budget, their statement of work, most recent audit report, conflict of interest disclosure, indirect rate agreement, or are they going to be using a 10% de minimis rate as allowed under uniform guidance? Obtain their technical administrative contact information and any other documentation that's required by the solicitation requirements. That subrecipient commitment form in bullet number 1 is going to be something that's unique to each university. You can develop your own. I know that ours includes things like not just we get their commitment to participate in a project. Should our joint proposal be selected for funding, they're going to be doing this statement of work and get paid this amount of money. It's not just the commitment that we're getting from them. We also take advantage of this opportunity to collect from them all the information that we're going to need later when we're submitting our FAFATA report, which we'll talk about, including their DUNS number. And I collect a bunch of information from them to perform a risk assessment. How risky is this subcontractor? How likely are they to perform successfully? And if it's a low likelihood, do I really want to move forward with this subcontractor because their failure to perform has a direct impact on my ability to perform on the contract? So this subrecipient commitment form is also a tool we use to perform a risk assessment that I'll talk about in a bit. We also want to check their audit reports. Have they ever had a negative federal audit finding in their history? Audit reports are available in a handy database, the FDP Expanded Clearinghouse, where everyone enters everyone who participates, which is hundreds of universities, submits their information, relevant information, and you can just check really carefully. If they're not a participant in FDP, if they're a company, for example, then you ask them, have you ever had any negative audit findings in the past couple years? And you have to kind of take their word for it. And conflict of interest disclosure, which is required. And they're only allowed to charge the indirect rate that in a federally negotiated indirect rate agreement that they might have with the government, or if they don't have one, then they're only allowed to charge a de minimis 10% rate pursuant to the requirements of OMB. Anything more, and if you get caught paying them more in an audit, you're going to be paying the government back. Also, when you collect the budget from the intended subrecipient, you want to look, if you're issuing a sub award under a grant, you want to make sure that your subcontractor's budget doesn't have a line item for fee or profit. Remember, I mentioned that under a grant or cooperative agreement, a fee or profit is an unallowable cost. Well, it's unallowable for you and your subrecipient. So make sure that that's not overlooked. So drafting the subaward, we're going to follow UMB uniform guidance steps. And the first thing we have to do is conduct this risk assessment. The government wants us as prime contract recipients to be good stewards of federal money, not to throw it out to risky enterprises who may not perform. So we have to perform a risk assessment, which determines how likely your subcontractor is to perform successfully. not only to satisfy OMB's requirements, but also to limit your own university's risk, because your performance is held accountable by the federal sponsor for your subrecipient's performance. You can't say, well, we complied, but the subcontractor didn't. The government contracting officer won't care one bit, because we have federal subcontractor oversight responsibilities, and we are required to make sure that they are performing properly. So how do you determine at the early stage whether they're a high risk or a low risk subcontractor? You look for things like, have they ever been debarred or suspended from receiving federal or state funding? And I know at Mason, we subscribe to a service which I can just type in their name and I can get a report called Visual Compliance. How big is this entity? Are they a brand new small company that's just formed and has no experience in the government marketplace? If they are, then maybe they're a little higher risk than I would like. What is the percentage of the prime award that's being flowed down to them? If I've got an award for $100,000 and they're getting 950,000 of it, then boy, I better make sure that they're low risk. Are they domestic or foreign? If they're located somewhere I can't perform a site visit or can't have more immediate control over them, they might be a little higher risk than someone who's local, or at least in the US. Are we working with export controlled, classified, or protected health information type of data? I don't want to be in a situation where they're going to violate any of the data security requirements, because that's going to come back on us. What kind of financial accountability do they have? My subrecipient commitment form has a bunch of questions about what kind of accounting systems they use, how they track time, how they track federal property. So I have a pretty good idea by looking at my completed form as to what kind of financial accountability they're going to have. Are there human or animal subjects involved in this research? And if so, does my subcontractor have IRB or IACUC approvals? They can't begin their research with human or animal subjects unless they've obtained the appropriate approvals. And if there are awards under a public health service funding, they have to disclose any financial conflicts of interest that they might have as an institution, or that their PI might have as an individual. So I'm taking a whole lot of this information in, and I'm trying to determine where they fall on a risk assessment criteria. So we kind of developed just a low, medium, high risk or unacceptable. And this was just sort of out of our heads, although this is always sort of a work in progress. You know, a subrecipient who's a university, who's established, financially sound, we have good working relationships with them in the past, or a large national corporation who's very reputable, you know, they're going to be low risk. Medium risk might be a large size corporation with a solid financial background, but we might have had a bad experience with them in the past, or they're getting a huge, large, you know, the 950,000 out of $100,000 award. You know, I might want to assign them a medium risk. Or high risk. I did a sub award to a tribe in Ethiopia that had no computer. It was sort of a nightmare, but they were absolutely critical to the project itself. So I couldn't render them unacceptable, but they were absolutely high risk. And I've only had one unacceptable situation where we instructed our PI, go back and find somebody more reputable to subcontract to. The reason I need to assess a risk at all, not just because OMB guidance tells me I have to, but because I'm going to need to know that when I'm drafting the terms of the subcontract, what kind of oversight responsibilities I'm going to provide to a low risk subcontractor is going to be different than the kind of oversight responsibilities I'm going to apply to a high risk subcontractor. And those include so if I've got a high risk subcontractor, I might add terms that limit the period of performance and or the funding amount into very small increments so that they're not going to get increment 2 until they successfully perform on increment 1. And that way I'm not out a large amount of dollars should they not perform. I might increase the frequency of reporting requirements. If I don't have much confidence in their ability to perform, they might have to give me monthly reports, status update reports, financial and technical reports, instead of quarterly. I might choose to issue them a fixed price contract instead of a cost reimbursable contract so that there's no risk that they still have an obligation to complete the project without the ability to ask for additional funding. But OMB uniform guidance says, if I'm going to issue a fixed price subcontract over $150,000, I need federal contracting officer's approval. That's a fairly new requirement. It didn't used to be that way. We used to have complete control over what type of subcontract vehicle to issue them. But now if it's a fixed price subcontract over the simplified acquisition threshold amount, then I need government contracting officers' approval. Frankly, I've never had the approval denied, but they need to be aware of it, and you need to be able to document your file so that an auditor will see that you've complied with the requirement. I can also provide additional oversight to a high risk subcontractor by limiting payments to the successful completion of a specific task or milestone. So instead of they're just allowed to invoice, $2,000 a month, regardless of their actual performance, I might say, you don't get any money until you give me this task or complete this milestone. So when you're drafting the subawards, you're going to make the determination fixed price or cost reimbursable. And again, a fixed price subcontract over the simplified acquisition amount, which frequently well, not frequently, but periodically changes. So you need to be aware of what that is. Is there any cost share? Did the solicitation guidelines require cost share? Was there mandatory cost share for you? And are you going to flow some of that cost share responsibility down to your subcontractor? Then you're going to have to draft your subaward terms to include cost share reporting. Are they an international subcontractor? International entities are not going to be subject to the laws of the United States like a federal, like a US company or university is. I've had international subcontractors tell me they won't accept any FAR flow downs because they're not subject to US law. And well, that's true, but I kind of dig my heels in and say, but I'm not taking the risk on your behalf. You're going to accept this or we'll find someone else who will take it. And you can always help them to see reason. What kind of reporting requirements are you going to require? Obviously, you want reporting requirements that meet the government's expectations, but if they're a high-risk subcontractor, you might want more frequent financial and technical reports. And what kind of intellectual property ownership provisions will apply? You're going to flow down those FAR clauses that allow either the 52, 227, 14, or 11, making sure that the government gets its government purpose rights, even from the intellectual property that your subcontractor creates, and then decide whether you're going to allow them to own their own or not. I know at Mason, we always do, especially if it's another university. That's just kind of the standard operating procedure between them. So subrecipient monitoring is a joint responsibility between your sponsored programs office and the PI. So this is all spelled out in Uniform Guidance, section 331. What are we monitoring? We're monitoring that your subcontractor is compliant with all federal regulations in their award. that they're complying with the prime terms and conditions, that their spending is appropriate, allowable, and allocable. Again, the cost principles apply to them that apply to us. That adequate technical progress is consistent with the statement of work and the invoices. So your PI is going to have to know before your PI authorizes the payment of an invoice, they're going to have the obligation to measure, is their spending commensurate with their performance? If they're invoicing us for a lot more work than they can actually show, then that's a bad sign, and we need to question what it is and maybe reject the invoice until we can get to the bottom of what their technical progress really is. So these are important steps that we have to take per uniform guidance. And if it's a prime contract, we're issuing a sub award under, and we have our funding only incrementally pursuant to each annual congressional budget approval. Our subcontracts have to mirror that. So our subcontractor is only going to get their share of funding 1 year at a time as well. So then you're going to start issuing modifications. And before issuing a modification which extends the period of performance, provides them year 2 additional funding, you have an obligation to do the following. Ensure that you've obtained your own incremental funding, your own modification from the federal agency. You don't want to give them money you don't have yourself yet. That you obtain the PI's approval and that their monitoring and oversight of the subcontractor has been satisfactory. That you review, once again, their debarment status, their audit status, and their performance. So you kind of go through a little bit of this risk analysis each year, and your risk assessment might change. It might improve if they're awesome, or it might go down if you've got questions. And then you might want to include some additional oversight responsibilities in their modification. Now let's talk about FAFATA. Stands for the Federal Funding Accountability and Transparency Act, part of the United States Code, Chapter 31, Section 6101. And here's what this is. So back when President Obama was an Illinois senator, it bugged him that the public had no ability to see where federal money ultimately goes. So let's say the Department of Defense issues George Mason University a $1 million contract. So the public has access to that knowledge. But then Obama was concerned, what does Mason then do with it? As taxpayers, we should have the ability to know what George Mason University is doing with that money. Are they further subcontracting to outside organizations? And if so, who? So he introduced the Federal Funding Accountability and Transparency Act while he was a senator, and a little while later, it became federal law. So now there is a process and a system for all federal subawards to be reported into a database that the public has access to. So if I'm issuing a subcontract to another entity, either under a contract or a grant or a cooperative agreement, I have a reporting obligation if that subaward amount is greater than $35,000. If it's lower than $35,000, I don't have to report it. But if, let's say in year 1, I give a subcontractor $20,000, I don't have to report year 1. But in year 2, I give them another $20,000. Now I've reached that $35,000 threshold. Now I have to report it in year 2, even though it's not a brand new subcontract. It's reached the dollar threshold for requirement purposes. So here's how reporting is made. Here's what's reported in this database. So we log into this date. Let me show you another slide first. Here's what you log into fsrs.gov and you get to this screen. And I click the awardee box and then I go through the motions and it's not a very intuitive database. Frankly, I don't like it, but I don't get a say, so I just comply. And I submit a report that includes these items: the subrecipient's name, their location, their DUNS number, the amount of the subaward, a summary of the statement of work of what they're going to be doing, the salary of their highest paid officials and executives, unless that information is available publicly elsewhere. And it must be updated with each modification. So let me go back to the first bullet where I've got their name, their location, their DUNS number. The DUNS number is what's generated once you are registered in SAM. And I need that DUNS number. That is critical. I cannot submit a FFATA report without my subrecipient's DUNS number. So that little tribe in Ethiopia, I had to get a flippin' DUNS number from them. Let me tell you how hard that was. But it's a requirement, not a university requirement. It's a federal requirement that any recipient of federal funds, either on the prime or subcontract level, has to have a DUNS number. So that DUNS number is, I put in a DUNS number and then it pre-populates about half the fields in a FFATA report. And I truly can't submit without it. So that's one of the pieces of information I collect on that subrecipient commitment form I mentioned earlier. And the location, and the congressional district that this entity is in, because part of what Obama wanted to disclose was, in whose congressional district is this money ultimately ending up? So it just to give the public transparency. How much money they're getting. And again, I have to update this report annually because if it's a contract, it's incremental. And they get 20,000 in year one, I just report 20,000, but then I go back when I issue that mod and add 20 more thousand. That's why I have to update the report upon issuance of each modification. A statement of work, so the public has an understanding of what this subcontractor is doing for their funding, and how much money are their highest paid employees making. So that they thought was an item of interest to the public. Now with the university, our salaries are public, so they're available elsewhere. So we don't, there's an exemption to reporting that if this information is publicly available. Here's the lovely picture of the opening screen. And this is what a FFATA report looks like, although it's much smaller and kind of hard to read. I hope you can see it on your screen. But we put in our award number and it pulled up our award, how much the prime contractor was receiving, how much of it's going out to the subcontractor, where that subcontractor is located, etc. So and then the public, they don't log into the FSRS database like we do. They log into usaspending.gov and they have access to a version of this. Oh, all right, that ends this slideshow. However, I want to pull up something else and go through it with you. I have a few more minutes with you and I want to I'm not going to go over this in detail. Open up. Okay, can you see this? It's a CRA exam legislation. I hope. All right, I want you guys to read through this and be familiar with some of these laws and federal regulations, just so you're aware of the issues. Some of these we talked about, some of them we did not. But these are federal laws that affect federal contracting. And they're usually in the form of a FAR clause, but here's the actual, summary of the law itself. So the official title of this one is limitations on use of appropriated funds to influence certain federal contracting and financial transactions. That means I can't use federal money to hire a lobbyist to steer an award my way. That's against the law. The Buy America Act, the Civil Rights Act, you as a prime award recipient are not permitted to violate Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of a lot of things. If it's a federal law or a research project involving healthcare research, you have to maintain the confidentiality of patient health information that's protected under Public Law 92-255. Clean Air Act, we have to make sure that we're not a polluter. Clean Water Act, same thing. We have to make sure that our people aren't abusing alcohol while they're performing on a federal award. We have to make sure that work hours and safety standards are kept reasonable for our employers. We have to make sure that we're not paying kickbacks to federal folks. We want to make sure that we're in compliance with the CREATE Act, Cooperative Research and Technology Enhancement Act, which talks about how jointly developed intellectual property is handled. Davis-Bacon Act, we have to make sure that we are paying laborers a standard or a decent hourly rate. We cannot receive federal funding or issue federal awards to others who are not, who have been suspended or debarred. It goes on. This is all pretty self-explanatory. And I've given it to you. I gave it to Eric to post on the site so you guys can refer to it as you're going through studying for the exam. You're not expected to have this memorized, but you are expected to understand the principles that apply here and what the government's trying to do in order to keep the contracting process fair and equitable. So that was what I wanted to present to you today. Does anyone have any questions? We still have a few more minutes. Anything you can think of?
Eileen?
Yes.
I had a couple of questions I saved from the chat while you were talking, and so I'll just read them for you. And since the chat doesn't get saved in the video anyways.
Okay.
I had a question on the 60-day clause. Is it 60 days from the day that you reach 75% of expenditures on a contract?
Yes.
Okay. There we go. Got a little clarification there. Where do you locate a prescription, in quotation marks, for a particular clause?
The beauty of the FAR is that when you go to the clause itself, like 52-227-11, that's the one that deals with ownership of intellectual property. It's got the clause number and the title of the clause. And then the very first thing it's going to say is, as prescribed in FAR chapter 12.203, it's going to tell you very clearly where the prescription is. And then you just flip back in the book or scroll back in the FAR document and you'll find it.
Wonderful. I'm pretty sure I know the answer to this, but I'll ask anyways. Can a subrecipient elect not to charge FNA if they do not have a federally negotiated rate on a federal award?
Yes, they can charge nothing, but if they don't have a federally negotiated rate, they cannot charge more than 10%. So it's either 10% or nothing.
Okay. And this is more of a university-based question. Does GMU do the FTP risk assessment at proposal or award stage?
We collect it at the proposal stage, but we don't do it until the award stage, because think about, I don't know what everyone else's university's success rate is, but let's say we submit, and I'm making up numbers, let's say we submit 10,000 proposals a year and only 2,000 of those proposals are awarded. So I would have spent a lot of time doing risk assessments for 8,000 proposals that may never be funded. So we do it at the award stage.
And then there was a statement earlier, I'm not sure if you remember it, where you stated fixed price plus.
Oh, cost plus fixed fee?
Sorry, can you repeat that again?
Cost plus fixed fee.
Ah, there we go.
So a cost reimbursable subcontract is ideal for a university because we're all not-for-profits. We don't have profit or fees that we're charging. We charge our actual costs plus recoup our indirects, and we're happy. But corporations are not happy with that. They want their cost, they want their indirects, and they want a fee. They want to earn a profit on it. So the government can issue them a cost plus fixed fee type contract. A lot of times a government contracting officer will say to me, well, what do you prefer, fixed price or cost plus? They limit, and I say, you can give me a cost plus, but the plus fee is 0. And then they're happy. It's semantics.
All right, and then this is would have been a great question. I wish I'd known this probably before I took the exam on FFATA. Does the prime have to report $40,000 as listed in the example, or the $5,000, which is above the 35,000 threshold?
40, all of it.
Okay. And does the FFATA apply solely to subcontracts or also standard purchases?
Nope, subcontracts only. No purchases. So when you make that determination about who's a subcontractor and who's a contractor being paid through a purchase order, you don't report those.
Perfect. That's everything then.
Okay. With 12 minutes to spare.
Woo!
Woo. Anybody else have anything that didn't end up in the chat? I've given you my email address on the cover page of the presentation. So if anything pops up, please let me know. And I want to wish you all the best of luck. Eric puts an awesome program together every year that's got a very high success rate. So good luck to all of you. You're in good hands. Thanks, Eric.
Thank you.